today's episode on democracy and the rule of law, and which is the issue surrounding the purported removal of the chief judge of Benue State. Barrister Yaji, can you help us make sense of that situation currently in Benue State right now?
Well, we woke up on a certain day and then we found out that there were videos circulating that some members of the had passed a resolution that the chief judge of Benue State be removed and that the second in command, the second most senior judge, be sworn in immediately. And of course, there were allegations of misconduct and impropriety leveled against him. Without looking into those allegations the allegations against the person of the chief judge, we immediately issued a statement. The statement was issued by the president of the NBA, and we followed suit to condemn the action as an illegality for breaching the clear and distinct provisions of the Constitution and decided authorities on the issue.
We wonder what are the provisions of the Constitution for the removal of the chief judge of the state. And of course, we understand that the members of the State House of Assembly, of course, swore to protect the Constitution as part of their oath. And of course, we believe that they will not deliberately violate the provision, the express provisions of the Constitution. So please, can you tell us what's the provision of the Constitution, because there are weighty allegations against the chief judge of the Benue State, which necessitated this removal. But probably you might want to enlighten us on this specific provision of the Constitution on the removal.
Okay, thank you very much. Section 292, subsection 1, B. Subsection 1A, sub 2 of the Constitution is a provision that they purported to act upon. That provision allows the House of Assembly upon a petition to recommend to the governor the removal of a chief judge of a state or a grand caddy, as the case may be. Now, they purported to rely on that section, and what we're saying is that that particular provision of the Constitution has already been interpreted by the Supreme Court in the case of Elenu, Habib, and another against the Attorney General of the Federation and others. And the decision there is that you cannot remove a chief judge, you cannot discipline judicial officers without recourse to the NJC.
Okay. Obviously, they are against. There is a conflict between the Supreme Court ruling and the provision of the Constitution, the constitutional provision which you just read, that the House of Assembly can recommend the removal to the governor, which obviously they are relying on now to purportedly remove the CJ. There's a little bit of misinterpretation in that area. But then, of course, going further on this issue, we have also learned that about 13 members of the House of Assembly has equally been suspended as a result of the fallout on this on the removal of the CJ.
Yes, that is what we've heard. Most of the reports that we're getting are reports that we've seen videos and commentaries by interviews by other members of the House of Assembly. Yes, there are allegations that those 13 that were suspended actually took part in they were among the 2023 that were there when the motion to suspend or to remove the CJ was moved. However, the 13 issued a press statement shortly afterwards that they were excluded from voting and that they did not participate in the voting of the in the proceedings of that day. Now, if there are 23 members and 13 are saying they did not participate in the motion to remove the chief judge, then it therefore means that there's less than 2/3, which is required for that action of sending the recommendation to the governor for removal of the chief judge. Now, the standing rules of the House of Assembly have rules that regulate themselves. So, without venturing into the rules of the proceedings of the House of Assembly, I am not sure if it is true that they actually participated, and then after the decision was made, they went back and reneged on the decision. Then it behoves on the House of Assembly to discipline its own members within their rules. So the issue now is, did they participate or did they not participate? And if they participated, did their suspension, is it in accordance with the rules of the House? That is what we are yet to see.
Yes, Yaji, we'll come back to you on the implication, the political, the effects of this removal on the independence of the judiciary. But before we come back to you on that question, let us take the opinion of Barrister Obiorah. So, Barrister Obiorah, of course, we have been inundated with this issue of removal of the CJ.
Yes.
I'm sure this is not the first time this CJ has been removed.
Yes.
Federation. So, what are the constitutional provision on the removal? Because it has cited that the House can recommend, and that the Supreme Court has also, invalidated that rule that they must go through the NJC and all of that.
Yes, over the years, it is usually the NJC that removes a judicial officer, in this case, a chief judge of Benue State office. I'm also aware of the fact that the people that purportedly removed the chief judge claim that they acted on the provisions of section 292A1 of the Constitution, 292A2 of the Constitution. And what does that provision of the Constitution encapsulate? It says that the governor can remove on the recommendation or address of the total majority of the members of the State House of Assembly on two conditions. One, where there is proof that the chief judge can no longer perform the functions of his office for reason of infirmity of mind or body, or, that's the second leg, on allegations of misconduct or breach of code of office. Now, the petition or the allegations against the chief judge by the members of the House of Assembly of Benue State is predicated on misconduct. The question that naturally arises is this: where there are allegations of misconduct that borders on fraud, misappropriation, can such allegation be acted upon by the governor without an opportunity of the person against whom the allegation is made having the opportunity to defend himself or herself? Where we all know that natural justice, which has been codified into our Constitution, 1999 Constitution amended, that has the right, has given the right to every Nigerian to fair hearing. Where allegations are made against any person or body of persons, the Constitution demands that such a person or group of persons be given an opportunity to defend himself or herself. And in this instant case, allegations were made against the chief judge, and without the chief judge being heard defending himself, they purportedly removed him. That runs contrary to the clear provisions of our Constitution, which is the highest law in this country. The Constitution is the ground norm, it's the highest law, and any law that is not consistent with the Constitution is null and void to the extent of the inconsistency. Of course, we know that the Constitution took a leaf from what happened in the Garden of Eden, where God did not punish Adam without first of all asking Adam, have you eaten of the fruit? And Adam was given an opportunity to defend himself. In this case, the chief judge was not given an opportunity to defend himself on the alleged misconduct. They didn't say that it had to do with infirmity of mind or body, inability to perform the duties of his office. Even then, if they come under that ambit, there is still need for proof that the chief judge cannot perform it. But that is not what they are coming from. So the question of removing him on allegation of based on section 292, they have not fulfilled the clear conditions because it's implicit. If you are saying that somebody has violated any law or committed any offense or done something contrary to the law, the person must be heard before punishment is meted out. And of course, the chairman of the NPA just reminded us of what the Supreme Court has already decided, that under the provision of section 292, under which they purported to act, it is still the Nigerian Judicial Council, the National Judicial Council, that is the appropriate authority to remove the chief judge. And in this case, I believe there will be need in future for the constitution to be amended to avoid a situation of this nature where members of State House Assembly will be purporting to act on the provisions of section 292, and they believing, because they were saying that what they did is within the clear provisions of the constitution, and they were even saying that the NBA president, Mr. Afamo Sigwe, did not read the constitution well before coming out to condemn what they did. Of course, apart from NBA president, many legal practitioners, Nigerians, and even international community are condemning what appears to be a caricature of the constitution and the judicial system. How can a group of persons decide that they don't want the chief judge, and then they just pass a resolution in the house, and then on that basis a judge?
Well, they said there's an allegation of that the chief judge has misappropriated about over 600 million naira within this year alone.
And that is what I've just said earlier, that is an allegation of misappropriation. And we know the clear thing that you cannot be the judge, you cannot be the accuser and the judge at the same time. They accuse the judge. Then a body, an independent body, should be allowed to investigate. And if there are proofs, then the appropriate authority, which the NJC would now take that appropriate authority. They cannot just levy allegations, no matter how worthy, and act on it without giving the person concerned the opportunity to defend himself. And of course, the normal thing that happens in life is that when there's allegations or petition against a judge to the NJC will carry out investigation whether the allegations contained the petitions are true or false. When those allegations are found to be true, then the appropriate punishment will be meted out by the NJC. All right. But where it is not true, it will be consigned into the dustbin. And in this case, the people that brought the allegation against the judge went ahead to act on it without a proper investigation into the allegations. And that is where they have failed to comply with the clear provisions of the Constitution. Because when they look at section 292, they forgot that before 292, there's section 36. Fair hearing, which is global, which is worldwide, not just in Nigeria. Anybody that has allegation made against him or her must be given an opportunity to be heard.
Okay, but obviously they might argue that if the chief judge feels that they have not followed the constitution, he might probably go to court to challenge his removal.
In as much as I know that the chief judge will take steps to remedy whatever appears to have been done, the NJC has come out to say that as far as the NJC is concerned, the chief judge still remains the valid chief judge of Benue State. All right,
let's go back to Mr. Yaji, because this seems to be, there seems to be a little bit of legal controversy here. Mr. Yaji.
Yes, I'm with you.
Okay, so before I ask my question on the issue of what does this removal do to the independence of the judiciary in in Benue State specifically and Nigeria? I want to get your opinion on the people who would want to say that if the chief judge feels that the removal is unconstitutional, he has a right, to seek redress in court. In light of the fact that even the NJC have said that he remains the chief judge, irrespective of what has happened in the House of Assembly. So which one holds water? Because some people will say for in order to follow due process, he should accept the removal and then go to court to challenge it. So what is your opinion on that?
Well, a void act, an act that is a void ab initio. Person can choose to avoid it. Now, what the House of Assembly did is an illegality completely. It is null and void to the extent of whatever decision that they took. The House of Assembly themselves seem to be at crossroads with the decision that they took. The videos showing the images of proceedings of that day said he was removed and that the next in line should be sworn in. Now, the resolutions that we have seen are showing that the House of Assembly has recommended to the governor for the removal of the chief judge. So, if it is recommendation to the governor on the removal of the chief judge, then what does the chief judge need to do? Nothing. He will sit down. He's still the chief judge. As far as the NJC is concerned, as far as the Constitution is concerned, as far as the governor has not said anything, he's still the chief judge. There's no need of saying, go to court and to seek those redresses. By the way, courts in Benue State have been closed since the 6th of December 2014 and 24. Till today, all the courts have been closed. It is equally a problem
issue for another issue
that we have been facing before this issue came in.
All right. Let's also get an opinion on the impact of this mild crisis on the public confidence in the legal system in Benue State specifically and Nigeria. Of course, people, the onlookers are watching. This crisis, and also the issue of separation of power and independence of the judiciary, because we understand that there is a principle of separation of power where each arm of government is different, and we have 3 arms of government in Nigeria, and before any arm can interfere, there are laid down rules. So what does all of this issue, what does it say about independence of the judiciary and separation of power, as it were?
Well, separation of powers, the 3 arms of government are meant to be separate from each other and to act as checks and balances on the other arm. No arm of government is supposed to be superior to the other arm. Each of the arms of government ought to be independent and to ensure that the decisions that they take are in accordance to the rules governing them. Now, for a House of Assembly to interfere in the manner that the Benue State House of Assembly interfered to purport to remove a chief judge, then it is sad for our democracy. It therefore means that, what if the chief judge now sits down with a couple of his judges, and then there's a case that is instituted, and he gives an order that all the members of the House of Assembly stand expelled or stand dissolved? How does that portend? Because as judges, they are meant to interpret the law and give orders. So what if they give an illegal order such as the one I've just explained? It will mean that it is a situation that they call a dog eating dog. The House of Assembly, within the confines of the powers provided for them under the Constitution, should limit themselves to those powers. They should not interfere with the duties of the judiciary vis-a-vis the duties of the executive. If there is mutual understanding that the 3 arms are different, everybody stay in your own lane, then democracy will thrive. But this is a potential danger to our democracy, and all hands must be put on deck to ensure that it does not hold and it does not stand, and it should be disallowed for the illegality that it is.
All right. Before we let before we call it a day on this particular topic, and we'll move on to the next topic, I want to get your advice, on the parties involved in this crisis, because I'm sure that some of them might be watching.
Well, if there are allegations against the chief, the law should take its course, but due process ought to be followed. With all due respect to the Benue State House of Assembly, due process has not been followed. And it is not about whether the allegations are weighty or whether they are criminal in nature or whatever the allegations are. The Supreme Court has laid to rest the procedure for removal of a chief judge. That decision is a decision that is yet to be set aside, and until that decision is set aside, the House of Assembly cannot remove the chief judge or ask for its removal without the input of the NJC. They are honorable men. I am sure that by now they would have looked at the process they followed, and as honorable men, they will retract and allow the chief judge to continue to function effectively, pending when they take the right steps to ventilate whatever grievances that they have against him.
All right, thank you very much. Stay behind while we look at the next topic on our Osun State election. So let me get your last opinion on this particular issue.
Benue State issue. Yes, I still want to add that what has taken place or purportedly taken place in Benue State is an affront on democracy, rule of law, and due process. It is completely wrong for this group of people to gather and then purport to have recommended the removal of the chief judge. Even if you look at the constitution clearly, it is not the House that the sessions provides that is to remove the chief judge. It's the governor on the recommendation of the members of the House. Now, and since it is very clear that...
Does it mean that the NJC doesn't have any input?
Pardon?
Does it mean that the NJC doesn't have any input in the removal?
It is usually the NJC that...
But you just said that is the House, the House recommends to the governor.
That is why I said earlier that there will be need for purposes of clarity to amend this section of our constitution. Because if you look at the wordings of the constitution simpliciter, it appears as if the House, upon recommendation to the governor, and the governor can, in compliance with that provision in the constitution, validly remove a chief judge of a state. And you know that this is not the contemplation of the lawmakers. One thing is this: the governor is here as an executive, the legislature is there, and then the judge is there representing the judiciary. Now, and for purposes of fairness, for purposes of due process, the Supreme Court has said that when the issue of removal of a judge, a chief judge of a state in particular, is concerned, it is NJC that will act. It is NJC that will act.
Okay.
And because the Supreme Court, in coming to that conclusion, have looked at the provisions of this section 292 and believes that it will be, going contrary to the clear provisions of our constitution and the hallowed doctrine of separation of powers, to allow the governor, on the recommendation of the members of the House of Assembly, to remove a chief judge. So because said no, that is not proper. That the proper thing is, if there are allegations, if there are things that the chief judge may have done that warrant his or her removal, you still need to have recourse to the NJC. And that decision is still valid and subsisting. And to that extent, what has been done is null and void for not complying with that judgment of the Supreme Court, which is the highest court in the land.
All right.
And like the chairman said, yes, I agree with his position that where a thing or an act is void, then it is void ab initio, and you don't even need to take any legal action to set it aside, except for purposes of ex abundantly curtailor out of excess caution. Just like Lord Dennis said in McFoy and UAC, that you cannot put something on nothing and expect it to remain. It will naturally collapse. So you cannot hinge the removal of the chief judge of Benue State on an act that, as far as law is concerned, does not exist, because it's void ab initio. So the chief judge doesn't even need to start bothering himself going to court to set aside an act that is void ab initio.
Ab initio.
Yes.
All right. Of course, it has been. Of course, it's your opinion that that act is void ab initio, and the chief judge did not worry going to court. And of course, the members of the Benue State House of Assembly, perhaps they would have another rethink and recourse to the Constitution to understand, the purport and provision of those sections,
yes,
and act within the bounds of the law.
Like I also said, there's need to, have a paragraph also inserted in that provision that the governor cannot remove without recourse to the NJC. It will settle the dust once and for all.
All right.